Hi, and welcome back to another episode of Intellectual Property. Today, we're going to be continuing our conversation about fair use. Specifically, we're going to talk about what I like to refer to as consumptive fair use and ask what the difference, if any, conceptually is between transformative and consumptive fair use. So, as you'll recall, in our last episode, we started talking about fair use and what it's for, right? We recognize that fair use is the kind of core federal common law, now codified limitation on the exclusive right of copyright owners, intended, among other things, to ensure that the scope and enforcement of copyright ownership is consistent with First Amendment values, and arguably also to ensure that the scope and enforcement of copyright ownership is consistent with the policy goals of copyright. In other words, that we're not allowing copyright owners to assert copyright ownership in contexts where it wouldn't ultimately be publicly beneficial. So there's an element here of this sort of big picture idea that the ultimate purpose of copyright protection is to benefit the public. And if we're concerned about copyright actually being used or potentially being used in certain circumstances in ways that would not be publicly beneficial or maybe would even be harmful to the public, we might look to fair use as a way of cabining those kinds of concerns or preventing those kinds of policy concerns from materializing. Now, in our last class, we talked primarily about what I like to refer to as transformative fair use. And we recognize that with the Campbell v. Acuff Rose case and over the course of the last couple of decades, the concept of fair use has been really bound up in this idea of transformativeness. In other words, after Judge Laval's famous article on the subject, which was highly influential on the Supreme Court, many other courts, many academics have taken up the idea that in order to determine whether or not a particular use of a copyrighted work of authorship is a fair use, you have to determine whether or not the use in question is transformative. Unfortunately, the concept of transformativeness has not necessarily gotten as much well-defined content as we might want it to have, and it seems to mean really different things in different contexts. I want to try to tease out some of those differences and see how they work in practice. So in our last class, we talked about Campbell v. Acuff Rose and other circumstances where the concern was about a person taking one or more elements of a previously existing work and using those elements to create a new work. In other words, fundamentally, what we were talking about were unauthorized exercises of the adaptation right, or the right to create derivative works, right? Because the works that these people were creating, the accused works in question, weren't literal copies of the original works. They were similar works that took elements from the previously existing work and used them as part of a new work, right? So historically, that's traditionally what we've thought of as being a kind of transformative use. In other words, when you take one or more elements from a previously existing work and use it in something new, what kinds of uses count as transformative and what kinds of uses don't count as transformative, right? In relation to the new work that's being created. In other words, when should a copyright owner be able to prohibit the creation of a new work because it incorporates copyrightable elements, and when shouldn't a copyright owner be able to prohibit the creation of a new work? And if you'll recall, right, in Campbell v. Acuff Rose, once again, the Supreme Court held that Two Live Crew was entitled to create a rap parody of Roy Orbison's song Pretty Woman, even though the copyright owner didn't want them to do it, because the use that they were making of the Orbison song was transformative, in as much as what they were creating was a parody, right? And a parody is a literary or artistic form that's existed for millennia that sort of uses copying and similarity as a way of poking fun at or illustrating ironic elements or qualities of ironies about the previously existing work, or sort of lampooning, as it were, the previously existing work and making fun of its meaning. And the Supreme Court said this is a valuable, or at least arguably valuable, literary form. If we don't permit some degree of copying, then it won't be possible to create parodies in the first place. Therefore, some degree of copying is necessary insofar as we're going to essentially define a parody as a transformative use. But of course, the court didn't limit transformative uses to parodies. Any kind of use that creates something new out of a previously existing work that doesn't effectively act as a substitute for the previously existing work, a market substitute for the previously existing work, is going to at least potentially be a protected use of the previously existing work. Of course, this then gets to sort of some of the long-standing criticisms of fair use, right? For a long time, people were pretty skeptical of the idea that fair use was of really much value, especially insofar as the copyright owner of the original work had the ability to bring a litigation action. For example, law professor Larry Lessig famously referred to fair use as the right to hire a lawyer. Of course, he wanted it to be more than that, but what he was recognizing was that there was a lot of uncertainty involved with fair use. And if fair use just means that, well, maybe you'll have an affirmative defense to litigation, that's pretty cold comfort for a lot of defendants who aren't in a position to be litigating cases left and right. And if fair use just means that you might be able to defend yourself, well, for a lot of potential users, they're going to look at that as not a realistic option for themselves. So in more recent years, the sort of the ability to exercise fair use has grown, right? Courts have become more sympathetic to fair use claims, and they've even begun to recognize fair use defenses much earlier in litigation, sort of recognizing categories of uses that are fair uses and not permitting defendants to proceed very far with litigation. What's more, there have been structural changes in some industries. For example, in the motion picture industry, insurance companies will actually provide insurance coverage against the risk of copyright infringement litigation if they're convinced by the insured that the use that they're making will be found ultimately to be a fair use. And that kind of amortization of risk among many potential defendants by insurance companies has actually made fair use a much more robust right, and one that, at least in certain industries, potential defendants can assert with much more certainty. Okay. So we recognize that there are certain factors, of course, that are considered. We recognize that transformativeness has become the sort of lodestar for the fair use analysis, even though it's sometimes a little hard to figure out exactly what transformativeness means. And at least in some cases, transformativeness sure seems to collapse into the effect of the product in the market for the work. After all, if you think about what actually happened in Campbell v. F. Rose, the court said, well, the rap parody created by Two Live Crew was a transformative use because it was, it parodied the original and it used elements in order to create a new work, et cetera, et cetera. But sort of in the background was the idea that, look, the market for Roy Orbison's Pretty Woman and the market for Two Live Crew's Pretty Woman aren't the same. And nobody would look at those two works as a substitute for each other. In other words, the people who want to listen to Roy Orbison's Pretty Woman are generally not the same person, people who want to listen to Two Live Crew's Pretty Woman. Therefore, it isn't really competing with the original. Therefore, maybe this isn't the kind of use that the copyright owner ought to be able to prohibit. So there's a kind of linkage between transformativeness and market effect that sometimes courts are reluctant to acknowledge, but really does seem to be there and important in how courts go about doing the fair use analysis in practice. But here I want to start talking about a different way that courts also think about fair use, one that they also characterize in terms of transformativeness but transformativeness in a really different kind of way than the transformativeness we're talking about in the Campbell v. Acuff-Rose sense. Okay, so let's return to the perfect 10 case. All right, as you recall, the court said that Google's display of the full-size images was not an infringement of perfect 10's display right in the photographs that it owned, because Google wasn't actually displaying the images itself. Rather, it was offering a pointer to third-party websites that actually contained the full-size images, and merely allowing viewers to sort of look through the internet to those third-party websites, as it were, rather than displaying the image itself. Sort of the implication being that, like, it's sort of like a shortcut, like the viewer could have clicked through and seen the image on their website. Google's just facilitating the user looking at the image on the website by bringing up a separate window showing just that one thing that's hosted on a separate website. But there was an entirely different kind of copying also at stake in the perfect 10 case, specifically the thumbnail images at stake. So you can see the thumbnails in the background. Those are what come up when you search for something on the Google image search website, right? It brings up a bunch of thumbnails. Unlike with the full-size images, the Google search engine actually copies and stores in its own servers those thumbnail images. Right? So unlike the full-size images, where Google is never actually storing the full-size image on its own computers at all, it's not reproducing, right? It's not reproducing copies of the files on its own servers. When it comes to the thumbnails, Google is reproducing copies of the thumbnails on its own servers, and those thumbnails are each embodiments of the photographic works in question, right? They're smaller, but it's the same image that's being reproduced just as a reduced size image. So then the question becomes, is the thumbnail storage an infringement of the reproduction right or not, right? And the court acknowledges that, there is a prima facie infringement, but it says that this is still a fair use. And why is it a fair use? Not because Google isn't copying the images, and not because Google's transforming how the images actually look. After all, the thumbnails are just smaller reproductions of the full-size images in question. It's because they're being used in a transformative way, not with respect to the individual images, but with respect to the images in the aggregate, right? In other words, the court says, look, this is still a fair use because it's still transformative. It's just transformative in a different sense, right? In other words, there is a use, as it were, that people make for the full-size images in question, or really any full-size image. Google isn't making that use. It's reproducing the thumbnail images purely for the purpose of facilitating the Google search product. In other words, without thumbnail images, Google couldn't have a Google image search, and Google image search is valuable to the public, right? So Google isn't creating these thumbnail images for the same market purpose that Perfect 10 is, right? In other words, Google isn't marketing the images. Google is marketing Google image search, and those thumbnail images are just the way that Google image search actually works, and it's not a competing use. Right? And the court points out, among other things, that, Perfect 10 hasn't identified a market for thumbnail images of these photos, right? To the extent it's making any money, it's making money by displaying the full-size photos, not these tiny versions. And therefore, Google isn't really in the same market competing with Perfect 10 by way of its copying, and it's offering additional value, right? It's using the images in a new way, and that use is transformative, even though it's not transforming the actual individual images themselves. It's transforming how they're used as a whole. Okay, well, something very similar happened in the Authors Guild v. hathitrust case here. What happened here? Again, Google is the defendant, as well as a consortium of many university libraries, research libraries. And what are they doing? Well, they engaged on a massive multi-year digitization project. where Google facilitated the scanning to PDF form of vast quantities of books from all of these libraries, many of which were very old, out of print, many of which were in the public domain, many of which were not, some of which were still commercially available, but many of which existed only in university libraries. Well, a group of authors were upset. They were concerned that the project as a whole was infringing on their copyrights and potentially harming the market for their work, and they wanted to stop it from happening. Right? So what did they do? They filed an infringement action on behalf of themselves and similarly situated authors and said, look, you're just creating copies of copyrighted books. To the extent that they're in the public domain, fine, that you can do that. Public domain works aren't protected by copyright. But to the extent the books are protected by copyright, that's just copyright infringement. What you're doing is infringing on our copyrights by making those copies and storing them on your servers. That's just a straight up reproduction of the works in question, and you're not allowed to do that. Well, hathitrust responded that, look, we're not copying these books in order to provide copies of the books to the public. What we're doing is providing a search function that enables users to search through this massive library of books for particular terms or particular phrases and see where they turn up, right? So all we're providing to users is a kind of a list of hits as to where particular terms show up in a particular book or a particular set of books. There's no way that users of our database can use it to actually read the book in question, right? All they're ever going to get are tiny bits and pieces of the book, not the book as a whole. Therefore, this is a transformative use. It's a non-infringing use, and you shouldn't be able to bring an action against us. And the court agreed. Again, similarly to like in the Perfect 10 case, the court said, look, on its face, there is a reproduction, but it's a reproduction for a totally different purpose. It's a reproduction for the purpose of creating a useful database that is transformative because it does something different than the market that the authors of these books, that the copyright owners of these books are engaged in. They're not selling the books, they're selling access to information about what the books contain. And if people are interested in that, they're still going to have to go get the books themselves. They can't use this database to consume the books. And copyright owners own a copyright in the books, in the literary works that they've created, not in any conceivable use of those works. This use is transformative because it's a use for a new and valuable purpose, right? Therefore, we're not going to stop them from doing this. We are going to deem it a fair use, right? In part because it's transformative, right? It's transforming the works by using them for a unforeseen and uncompeting purpose. But that uncompeting part also suggests the extent to which they're not actually infringing on the market for the books in question, right? So the authors are upset because of the copying, but they can't point to any actual market harm because what's being provided isn't copies of the books, isn't the work that they actually own a copyright interest in. It's information about the works. And therefore, the court says we should treat this as a fair use because it's valuable and it's something that we actually want to see happen, not something that we want to prevent. Okay, well, there's a really important case about this concept of consumptive fair use and how it relates to consumers. And that's the Sony v. Universal case. What happened here? Well, back in the early 1980s, we saw the introduction of the very first VTRs, or video tape recorder machines. One from Sony, and then there was also another machine. There was a Sony Betamax, and there was also the VCR. The VCR ended up kind of dominating the market. It's pretty rare to see a Betamax out there these days. The format didn't last all that long, except in a professional format. It was very popular among video professionals, but the kind of the default consumer format after a period of time was VCR, in part because VCR tapes could hold a longer program, which made them more appealing to consumers, among other things, right? So essentially, VCR went on the market, but the Sony Betamax was the first to hit the market, the first like commercially available, arguably a relatively consumer affordable machine that would allow you to tape videotape material that was broadcast on the television, also enable you to videotape material using a camera, et cetera, and to play back tape materials. New technology. People didn't know what it was going to be used for. People didn't know what consumers were going to do with it. And the movie studios flipped out, right? Because at that point in time, if you wanted to see a movie, what did you do? You went to the movie theater, right? That was the main profit center for movie studios, was showing films to the public where people would watch them in the movie theater. This new technology came out that was going to enable people to create their own tapes and watch material at home. And they were very concerned, right? Because the worry was that people would tape programs, movies off broadcast TV, and then build up a library and watch stuff at home and not go out to the movies anymore, right? So they were very upset. They wanted to figure out some way of squelching this technology, preventing Sony from selling this nefarious machine to consumers, or at the very least forcing Sony to cough up some kind of tax on each machine or each videotape that it sold in order to compensate them for the anticipated lost revenue from the machine. Okay, well, Sony's response was, look, this is a machine that can be used for lots of different things, right? One of those things is taping material off the TV and rewatching it. And sometimes consumers might tape copyrighted content and make reproductions without the permission of the copyright owner. But they can use it for lots of other things as well, right? There's public domain material that's broadcast that they might make copies of. Some copyright owners might want consumers to make copies. I mean, actually, Mr. Rogers testified that he was thrilled about the idea that consumers would be able to tape his show for their children and allow their children to watch the show whenever Mr. Rogers' Neighborhood, whenever they wanted to. And that ended up being kind of the core argument that drove the Supreme Court's conclusion. The Supreme Court said, look, this is a technology that has lots of different uses. Some of those uses are infringing. Some of those uses are non-infringing, but it's just a technology that can be used for lots of different stuff. And one of those legitimate purposes that it can be used for is creating copies of copyrighted works of authorship, audiovisual works, TV or movies broadcast on TV, so you can watch them at a more convenient time. Right? I mean, the broadcasters are showing this stuff and you can watch it for free. Without the VCR, without the Betamax, you can only watch it when they're broadcasting it. But what if you're not at home then, or you have to go do something, or it's an inconvenient time? Well, the machine allows you to tape it and watch it at a more convenient time for yourself. And that time shifting, as it was called by the court, was characterized as a form of fair use. Now, is it prima facie infringing? Yes. Is it transformative? I mean, not in the Campbell v. Acuff-Rose sense, but it's transformative in the sense that it's really useful for consumers. Now, was the court using the transformativeness paradigm in this case? Not really, right? But it was kind of saying the same thing, right? It was saying, look, this is a productive, non-competing use of the material. People are going to be able to watch the stuff for free anyway when you broadcast it. This just enables them to watch it at a more convenient time for themselves. That's not harming you, movie studios. You don't need to worry about that. This is a fair use because it benefits consumers without harming copyright owners in any kind of meaningful, tangible way. And side note, you might realize, or you might be thinking to yourself, gee, what did people actually end up using VCRs for? Well, they used them for watching movies that they rented from video stores. Right? What actually was the consequences of this new technology? Well, movie studios made a lot more money, right? All of a sudden, they were able to sell movies to vastly more people. People started watching vastly more movies than they ever used to be able to watch before because they could go to the video store and rent them. So this turned out to be a massive gold mine for movie studios, right? VCR rentals and sales dwarfed the profits that they made from movie theaters in a relatively short period of time, and were a massive profit center for these movie studios. Even though, ironically, a few years earlier, they've been trying to crush them. They were so worried it was going to destroy their business model that they were absolutely terrified. It turned out that it was a massive boon and a huge source of income for them. Right? We've seen something kind of similar with digital streaming and digital downloads, right? The music producers, music publishers were terrified, horrified by this for a very long time, right? They streaming and downloading was the worst thing ever, characterizing it as a crime, so on and so forth. And then it turned out, from their perspective, this was actually an amazing boon because they could sell stuff at a huge markup without having any distribution costs related to the physical media, right? All of a sudden, basically almost all of the transactions costs, or many of the transactions costs associated with their business model, just disappeared, and all of a sudden they were generating way more profit. Now, was that profit distributed equally? Maybe not so much, and there are a lot of concerns about that, right? But there's still a lot of money being made in that format, even though people were terrified once again about this new technology, right? So, moral of the story, right? When a new technology comes along, it's often very disruptive of existing business models, but maybe not always disruptive of existing players in various business environments, right? After all, the movie studios were horrified by the VCR. It turned out it was a huge benefit for them. It did disrupt the industry, but it disrupted in a way that ultimately was a huge benefit to them, right? So, spend some time thinking maybe about the relationship between copyright, authorship, and technology, and how technologies can change, the way that people go about consuming, owning, understanding, and experiencing works of authorship.